going live on the internet. So I think I might just get started if everybody's happy with that. Good afternoon. Can I just check that everybody can hear me? And I was going to say to wave if you can, but I see a lot that the videos are turned off, so I would be none the wiser if you were waving to me or otherwise. My name is Elspeth Cook, and I'm a reporter with Planning and Environmental Appeals Directorate, and I've been appointed jointly with Karen Haywood. You'll see Karen Haywood coming up as a number today on the screens. We've been appointed to hold the inquiry and report to Scottish Ministers on this application submitted under Section 36 of the 1989 Electricity Act for a proposed wind farm at Strathy Forest, south of Strathy in Sutherland, generally referred to as Strathy Wood. As you know, in Section 36 cases, it is the Ministers that will decide whether or not to approve the application after consideration of our report of the inquiry. This meeting concerns the arrangements for the inquiry and other procedures necessary to consider the case. It does not involve hearing of any evidence or the merits of proposals today. We've circulated the agenda at the beginning of the month, and you'll have had an opportunity to consider our current thinking on the matter. Consequently, we would expect to proceed quickly through the various points, pausing only to discuss any areas of disagreement. Due to COVID restrictions, Ms Haywood and I are not able to be in the same office today. This obviously introduces some limitations on how we jointly chair the meeting. So it's been agreed that I would act as chair and, where necessary, ask for Ms Haywood's views on any matters that arise. We'll aim to keep any such disruptions to a minimum. The meeting is being recorded and broadcast live. Callum will stay online in case of any technical difficulties. In due course, the recording will be available to view on our website. And as you will be aware, in accepting the invitation to the meeting, you have already agreed to be recorded. You might find it useful to use the grid view today in our meeting. And please mute your microphones when it's not required, as this reduces the disturbance to the general proceedings. I'll be watching the participants when they turn their videos on, and if you want to attract my attention, you just need to wave or raise your hand in some way. I think most of us have found that these simple signals are working quite efficiently in the online meeting platforms. If you're not expecting to participate at all and you're here to follow proceedings but are not likely to speak, then it's quite acceptable to leave your video switched off and just follow the meeting on an audio basis. Even though it's a virtual meeting, it's still useful to make sure your mobile phone is turned off or turned to silent. And as you'll be aware, the Scottish Government takes the COVID issue very seriously, and we would expect all parties, even in a virtual meeting, to make sure they're following the appropriate COVID-19 restrictions at the location where they're based. And obviously, if you're sharing your office with other parties or in a place of work, if you're not following the correct safety procedures, we do reserve the right to close the meeting and reconvene when appropriate arrangements have been put in place. I haven't planned any formal break in today's meeting, but I'll review this after about an hour and see what progress we've made, and we can decide if we think we need a short pause at that time. Now leads me to look at formal introductions beyond myself. I'll maybe just very briefly get Karen Haywood just to say hello and acknowledge that she's here. Karen, are you able to just give us a look?
Yes, thank you, Elspeth. Hello, everybody. As Elspeth said, I'm Karen Haywood, and together with Elspeth, I've been appointed to conduct the inquiry and write a report for Scottish Ministers.
And then I'll invite the applicant, perhaps to Emma Reid, to make their introductions. What I would like to raise, however, is an error possibly of mine. The agenda lists E.ON Climate and Renewables UK Developments Limited as the applicant, but I think the position statement confirmed that this had now changed to RWE Renewables UK Developments Limited, and I just want to confirm that's the case before we get underway, but perhaps Emma can clarify that when she starts her introductions.
I'm not. If I may just introduce myself, ma'am, I'm Vincent Fraser, Queen's Counsel. I will be representing the applicant at the inquiry. I think Miss Reid was just about to come in, but I noticed she was muted, so I wasn't sure whether she was waiting for me to jump in. Which, if it were old-fashioned proceedings, so to speak, it would have been me doing it. I can confirm that you are correct. All this is a change of name, in fact, in reality. But the applicant is now RWE Renewables UK Developments Limited. I don't know if you wish to hear from Ms. Reid. I'm sorry to interrupt.
Well, my intention really was to find out who everybody was that was with you from the applicant's side. We've got a list of names, but we don't necessarily have clarity over their particular role in today's meeting.
Yes, I can do that if it helps you, ma'am. My instructing solicitor is Mr. Gary McGovern, who I can see is participating, and Miss Emma Reid, both of whom are participating. Mr. Simon Lejeune, who you have down, is from the applicant itself. Mr. John Mason is our landscape witness. Mr. Bell is our planning witness. And we have Lauren Kellaway from Atmos, who effectively has been involved in collating the information for the EIA.
Right, thank you, that's helpful. If I could go to Highland Council now, who's speaking for Highland Council?
May it please you, Madam, it's James Finley, Queen's Counsel. And I, on the call today are Karen Lyons, Simon Heinson and Gillian Pearson.
Could I just check, Mr. Heinson joins us at a late stage. Could I just confirm his role for Highland Council?
He's a planning officer. He may well be involved in the policy or conditions, or may not. We're yet to completely assign roles, but he's a planning officer at Highland Council.
Thank you, that's helpful. And obviously we were due to have the RSPB here, who have pulled out from the meeting, and it just leaves Wildland Limited. I'm assuming that's just Mr. Kelly, is that correct?
Thank you, ma'am. Yes, but it's just myself, Ian Kelly, planning consultant, representing Wildland Limited.
Just at this stage, are there any preliminary questions or issues you want to raise right at the start that wouldn't obviously be fitting in more conveniently into other items on the agenda? Everybody happy that I just crack on with the next item? Okay, item 2 is the code of practice. As you all know, really, I'm speaking to people who are very well versed in this process. There aren't any rules for inquiries conducted under the Electricity Act, and the DPA has produced a code of practice that's modelled on the normal planning appeals regulations. We expect to apply the code of practice in this case. If you haven't seen the document, then it's available on the DPA website, but we'll also include a link to it in our note of the meeting. The purpose of the code is to make sure the process that we follow is fair, robust and efficient. It recommends that we put in place arrangements that ensure all parties are clear about what's expected of them before, during and after any inquiry or hearing session. It also allows us to tailor the inquiry procedures to each particular case, which means only significant matters in dispute need to be considered by formal inquiry process. Therefore, in addition to the inquiry route, which gives the opportunity of cross-examination, the Code offers us 3 other options which are less formal: a hearing session, which is a discussion led by the reporters, further written submissions where parties submit their evidence in writing, and or to opt for no further procedure where it's considered sufficient written material already exists. You'll see in the agenda and in its annexes that we've already set out where this flexibility could be applied, and we'll discuss this in more detail in due course. It also, I thought, might be helpful at this stage just to confirm that we have carried out our unaccompanied site inspections of the site itself and the various viewpoints. This was carried out before the current travel restrictions were put in place. We're not expecting to have to repeat any of these on an accompanied basis, but if it becomes apparent that additional site inspections are required following the hearing of evidence in the coming months, then we'll make the necessary arrangements to do so. Does anyone have any general queries on the Code of Practice and the options that it offers? Right, that takes me on to the next item, another bit of official business. Just to confirm, it's clear from the agenda we're not changing anything here. This inquiry or the hearing sessions will be carried out online. We don't expect to return to face-to-face inquiries within the preliminary timescale that we set for considering this case. Therefore, we don't see any benefit in making any provisional plans for a face-to-face event that would run concurrently with those that are required for the virtual event. However, you'll see that we intend to continue monitoring the government advice on this matter, and we will reconvene a meeting of parties or exchange correspondence should a significant change in the guidance require us to reconsider this position. As I think all of you know, we've completed a number of virtual inquiries and hearings now. I think some of you have been involved in them, and we're continuing to refine our procedures as we gain more experience in this area. So the exact arrangements of how the virtual event will be conducted, including the choice of online platform and testing arrangements, will need to be finalised near the time. And I would expect to be doing that at roughly the same point as we're finalising any programme for a hearing or inquiry session. However, and I'd like to raise it now because it's really useful in terms of your timetable of your own attendance. One important tip that we've learned is that when we're testing out technology and in fact Wi-Fi and broadband signals from the various participants, it's really important that the testing is done at the place where you would be conducting or joining the inquiry and not from another location. So we've discovered that there can be some testing issues if we've tested the wrong broadband or Wi-Fi signal. So in terms of a timetable, you might want to consider that in terms of how we lead up to any inquiry session. Does anyone have any queries or issues to raise regarding the virtual inquiry approach? Mr. Fraser.
Yes, may I raise 2 matters, ma'am? I have had a message actually from some of my team that they're not finding it that easy, I think, to hear you, I'm afraid. I hope this doesn't apply to me as well. But I do also have a point I wish to just raise about that. We recognise, ma'am, that realistically, given the timescales, it probably will be the case that it will have to be a virtual inquiry, as you've indicated. But the applicant's quite firm preference would be to have what I might term a traditional inquiry, if that were possible. So I just flag that up at this moment. But we appreciate that effectively your hands are tied at the moment anyway. The only thing that does occur to us, whilst we don't want resources to be wasted in any way, we do wonder whether it might be worthwhile at least to make some inquiries as to whether there would be anywhere available. Because what we wouldn't want to happen is for the guidance to change so that you could hold the inquiry, but effectively we're then faced with a situation where the time has passed, so to speak, to find anywhere. So I do flag up whether that might be a useful measure to put in place at the moment.
If I could take your first point really about being able to hear, I appreciate everybody's being very kind and not putting their video on. But if they're having difficulty in hearing me, I have no way of knowing because nobody can signal to me other than Mr. Kelly, Mr. Fraser, Mr. Finlay. So I'm happy to try my best, or indeed Callum will assist us if we're having problems with the signal. But without some way of people being able to signal to me, there's not a lot I can do to help them at the moment. The second point, that face-to-face inquiries, I accept most applicants and a lot of the third-party groups would prefer face-to-face events. There's just there just doesn't seem to be enough certainty in the way that the regulations and restrictions are being put before us for us to have any confidence in planning a face-to-face event. And at the time we're at in sort of in the middle of a transition through the Christmas period, I'm less inclined to make any undertaking. I do accept, however, that there is a need to look at potential locations, and I think we, without knowing the final points of separation distances and things, but if we were to conduct an event, face-to-face event, in similar restrictions that were present in the summer period, we know it requires a room of some considerable size. I think Mr. Kelly may have been involved in the event at Abbey Moor with colleagues of mine. And I think we do need a very large room, so I'm pretty certain we're limited to events, venues that would be somewhere in Inverness, Abbey Moor, where there are large function rooms. We're not certain that there will be anything local in the northern Sutherland area, such as Strathy or Thurso, that would have sufficient space to accommodate the spacing that we require. So we're pretty certain if there is any face-to-face event, it would need to be in Inverness or Abbey Moor, where the larger hotels may be able to offer the space that we need, but also there needs to be quite a lot of process put in place to do with other safety procedures for cleaning regimes and such things. So we know we've got to come down into the bigger towns to do that. So we can have a look at the availability, perhaps tentatively, once we have dates in place. But we know we're really not going to be looking at anything just now in the local area. I think the use of local village halls or other community venues is not going to be suitable for these events. And that's just one of these things, I'm afraid, we're dealing with that restriction. Is there any other points regarding the virtual process? Right, we'll move on then to our next item, which is really dealing with more of the substantive issues to do with the inquiry and the evidence itself. There are two key areas where we would expect to have some kind of update, regardless of any other procedure that we agree on today. And the first of these relates to landscape and visual impact information, and also issues to do with impacts on the wildland area. We identified in the agenda that updated cumulative landscape and visual impact information was likely to be required. And our thoughts have changed slightly since we received the Nature Scot submission of 17th November. Now that was circulated to everybody so that you saw this new piece of information and you could see from that there could be some issues for us in how we move forward. So I've now refined my thoughts, or our thoughts, on what would be the necessary update. And there are 4 points I'd like to raise with you. The first is the updated cumulative landscape visual impact assessment, which you were well aware of, that should just look at whether there are new wind farm proposals at application or scoping stage, or if any other fundamental or large scale proposals have moved from application to consented schemes, and also to look at the scoping stage of the proposals to change the height of the turbines at Strathy South. I think that's all in the public domain now. Second point I'd like to ask you to consider is submitting more written information or evidence on the impacts of the aviation lighting. Now, the position statement that the applicant has prepared indicates that the Civil Aviation Authority has agreed that only 8 perimeter turbines need to be lit by the 2000 candela lights. That's not the proposal that we have before us, and it's not the one that's tested through the most recent information on visual effects or landscape effects. I think the reference is at paragraph 3.5 of the position statement. So we really need to look at some additional information that brings forward this change to the lighting proposals, if it is a fixed and agreed position. The third point is then to review the nighttime aviation lighting effects, taking account of this change to the number of lights and their location on the particular turbines. And the fourth item would be to look at a specific assessment of the aviation lighting as amended, if necessary, on the wildland area at East Halliday Flows, taking account of any changes. So those are the four items that all stem from the general heading of landscape visual impact assessment. And just before seeking your views on this, I just want to confirm that any information received on this, we would expect to go back to Nature Scot and look for an updated view on any additional information that's provided. So my first question really on this is, what are the parties' views on these four main topics? And what do they envisage as being a reasonable timescale to complete this? You'll see that my preliminary timescale looked at the 11th of January as a possible submission date for this information. So I'll put that across to maybe Mr. Fraser first.
Well, dealing with the first issue first, ma'am, which is providing the additional information, I don't think we have any difficulty at all with that. Can I just understand, though, I wasn't quite clear with respect to the second item that you wanted. What precisely, by way of additional information, you want? I understand that you want flowing from the fact that it would just be 8 turbines being lit, further effectively landscape and visual assessments from them. And I understand that to be items 3 and 4, but I wasn't quite sure what more information on the lighting itself you were looking for. Sorry, ma'am, I think you're muted at the moment. I'll mute myself for now.
Okay, we'll get it all out of the way at the beginning. Yes, what it is that the position statement tells us that there is a proposal for 8 lit turbines and that the Civil Aviation Authority have agreed to that, but there is no documentary evidence of either a revised scheme or of the Civil Aviation Authority's agreement. So it's really to look at the evidential basis for a change to the proposal, and then to use that as the starting point for updating the assessments. Mistake has been Mr. Fraser.
I think I must have pressed the button twice. I do apologise. I understand that, ma'am. That's very helpful. Thank you. If those behind me who have to do all the work on that think they need anything more by way of guidance as to what's required, I'm sure they'll jump in after me. But I understand that. That's very helpful. Thank you, ma'am. With regard to the timescale, we would want a little longer, I think, if we could have it beyond the 11th of January for reasons which I'll explain in a moment. But I would note anyway, ma'am, my understanding about the council's availability is that effectively, I think the inquiry is going to be pushed back about 3 weeks or so anyway. So I think what I'd be asking for probably would leave about the same amount of time between the information being provided and when realistically we might hope to be proceeding. And so I think what we'd ask is if it's possible to substitute for the date of I think it was the 11th of January, the 1st of February. One of the reasons for that, ma'am, is that we're hoping really to get some agreement with Nature Scot as to just precisely where they want us to do things and how they want it done. We may not be able to agree on the ultimate judgment, but we're hoping that we can actually avoid any disagreement about what should and shouldn't be done, so to speak. And so we obviously need a little bit of time just to do that. And then we obviously also need some time to do the work, bearing in mind, although it's going to be a slightly unusual Christmas period, that is intervening partly between now and the 11th of January anyway, to make things a little bit more difficult. So if we could have until the 1st of February, I think that would be it would assist us and probably be a realistic date to which we could work to. Could I just ask, whilst on this topic too, I think in your agenda there is a suggestion perhaps that you yourselves might be identifying some selected viewpoints you wanted updated visualizations from. If that's intended, we're very happy to hear from you, ma'am, but I don't think we've seen anything yet. What we're trying to do, I think, it hopefully is agree just what extra material is needed, and then we'll get it done.
Thank you for that. In terms of visualizations, we're not going as far as being precise, but I was conscious that some of the council's evidence, and certainly Nature Scots information, leads us to think that there may be additional visualizations would be helpful, but we were leaving it up to the landscape professionals to look at where additional clarification could come from additional work in that area. Maybe just go to Mr. Finlay and see if he has any views on that.
No, I don't think Highland Council have any particular views. I can understand why a little bit more time will be needed. Certainly, as well as the written evidence on aviation lighting, it would be helpful also, and no doubt this would come in any event, to have clarity on the type of lighting and the strength of lighting. Because there was some considerable discussion at the recent Clash-Gower inquiry as to lighting and the difference that the different strengths of lighting may have by way of impact.
Ma'am, I'm sure that's been noted, and we'll take that on board.
Ma'am, you're muted again, I'm afraid.
So I pressed the button at the wrong time. Yeah, I'll make sure that's added to the note of the meeting. It kind of fits into item 2 on my list of things, just additional evidence regarding lighting itself and how that's going to be tested. Mr. Kelly, did you have any views on this point?
Thank you, ma'am. Just picking up on the point made by Mr. Finlay on the discussion at Clash-Gower, it may be that further visualizations are needed in terms of assessing the impact of the aviation lighting, particularly in terms of cumulative effects. Going back to your 4 original points, ma'am, we're of the view that the wildland assessment in the EIAR needs to be updated to take account of the current and emerging cumulative position, not just the LVIA to be updated. Thank you, ma'am.
Yes, I think my point specifically mentioned wildland impacts, so I think I would be covering that in the note of the meeting. Now, just when we're on that discussion and it's slightly more ordinary query, in what form of information would you be providing on the 1st of February? Would we be getting new hard copy LVIA documents on the 1st of February, or just digital documents at that point? Obviously, it's quite important in terms of the lead-in and any other witnesses that would be involved in any inquiry or hearing session.
I don't know the answer to that. I don't know if any of my team who are present are able to give you the answer immediately, ma'am, but I'm not able myself to give you that answer.
Well, I'm not seeing anybody lighting up their view to join us to tell me anything. So I
don't know whether they're discussing it between themselves, or it may be something you want to come back to in a few minutes. If
well, yes, there's not a problem. I think because we can catch things like this at the end of the meeting, perhaps just any of the procedural items. I really don't have any particular issue with moving the date back. I had imagined that might be a possibility when we added in the additional requirements and when we saw the nature of Nature Scott's comments. So using the 1st of February as a starting point for other timescales, I think it's going to work quite well, and we'll come back to that as we look at other things in the course of the meeting. Mr. Kelly, I think I saw you raise your hand there.
Thank you, Ma'am. Yes, the answer to your question is actually quite important in terms of setting the other dates, because as we've had at Clashgower and Rothes, as we had at Glensherrill and Aracleoch Extension, I will need hard copy of all visualizations that are to be referred to in evidence, including new visualizations. Everything else electronically is absolutely fine, but visual material I need to see in hard copy, and obviously I need to see that an appropriate period in advance of submitting any inquiry reports, hearing statements, etc., etc. So when we get hard copy is quite important, ma'am, in setting the other dates. Thank you.
Okay, we'll come back to that perhaps in a review of the dates, perhaps at the end of the meeting when we look at the other changes that might need to be made as we carry on. Now, the second item of update, and I think perhaps we'll be debating this again in more detail in further on with the inquiry, but we will definitely need an update of the current and relevant council and government policy or legislative guidance on this matter at some point in the run-up to any inquiry or hearing procedure. It could be that this matter might fall into the area of agreed matters, which is also coming up on this agenda. And it could also fall into any other procedure or written submissions procedure. So I'm really not looking for a view from you on this at the moment, but I think what we'll do is when we come to discuss issues of policy submission in other items on the agenda, we'll look at where best to provide that update in terms of timing and whether it forms part of another submission or process that is appropriate for discussing policy. So I'm really not going to ask anything just now, but just to park that issue, and we'll come back to it when we're discussing the issue of any statements you wish to make regarding compliance with policy, and we'll look at how best to deal with the update and list of relevant policies. Now that takes us on to the items that we've identified as potentially not requiring any further procedure at all. That was in Annex A. I don't know if anybody has anything to add or any concerns regarding that. Mr. Fraser? Mr. Finlay, do you have anything on the no further procedure items?
No, we're happy with.
And Mr. Kelly?
I'm happy with that list, ma'am. Thank you.
Thank you. And then we're looking now at the items under Annex B where we felt further written submissions might be an appropriate means to consider the issues that have been raised. Now, these all stem, or most of them stem from the RSPB representation that was submitted in response to the 2019 updated environmental information. And it's confirmed in their letter of October 2020. Now, they've obviously opted out of the meeting today, which is unfortunate, but they are agreeing to the procedure that we've put in place in the agenda papers. Now, the purpose of the written submissions firstly on ornithological matters, it is relating to their concerns over some of the methodology and conclusions reached predominantly with regard to the species red-throated divers. So we're looking for the applicant to respond fully to the outstanding matters on this issue. We're aware that Nature Scot withdrew their objection relating to similar issues. So we're really looking for some guidance and direction in evidence from the applicant on how they view the RSPB comments. The reason for that is the position statement from the applicant did not appear to realise that the RSPB had commented on their 2019 information, so there was a gap in that. Now, how do parties feel about addressing the ornithological information on a written submissions basis? Mr. Fraser.
Ma'am, we're happy with that. I think your observation about our understanding the RSPB's position probably is correct, but we're certainly happy to deal with it by way of written submissions, and we think that that's the appropriate way to deal with it. Is it appropriate for me at this stage, just whilst I've got the microphone, to raise a question that relates to wild land, to Mr. Kelly? As regards further updates, I noticed he was also, I think, seeking an ornithological cumulative impact assessment. Now, I don't understand that to be something you were asking us to do in respect of wild land. I just flag that up now in case we've been at cross purposes.
I hadn't been looking for any update in terms of cumulative impact. It was more as a means to respond to the RSPB outstanding matters.
Yeah.
Mr. Kelly.
It's our position that we do need an update on cumulative ornithological matters to take account of the latest proposal at Strathy South, and also to take account of the effects on the Caithness and Peatlands SPA from the Amoyne spaceport proposal, where there were objections from the RSPB and a late change of mind from Nature Scot. So it's not just an update in relation to this wind farm, it's an update in relation to the cumulative effects from the change at Strathy South and the proposals for the approved proposals for the spaceport, which also have effects on the SPA. Thank you, ma'am.
Mr. Fraser, do you want to come back on that?
Yes, ma'am, if I may, please. Ma'am, we don't consider there to be any reason to provide further updates on the cumulative impact. If I may deal with the points raised by Mr. Kelly, with respect to the Space Hub, it's our understanding that the EIA that was done for the Space Hub concluded that the Space Hub itself was such a distance from other developments that there wouldn't be any cumulative effects, and that obviously ruled Strathy out. Space Hub obviously sees itself as something on its own, and we don't see any reason why we'd be coming to any different conclusion. It's something that's been looked into effectively, and there's nothing new to shed any doubt on that. With respect to matters more generally, ma'am, the fundamental point we'd say is that in reality, any issues that are raised with respect to Strathy would arise from concerns about displacement, disturbance, or barrier effects due to the complex itself, and they've already been considered in depth in the information that's been provided. There's nothing effectively that's changed since then that would give any cause for it to be revisited. And indeed, of course, in any event, the Strathy South scheme itself will, if it comes about, will have to address any cumulative impact effects itself. So we don't see, ma'am, at the moment, any basis for further updates, so to speak, to be provided in relation to that matter. If it would assist you to have a short note from the ornithologists just explaining those matters to you, ma'am, I'm sure we can get that done. And I think I've been told it could probably be with you within, one would hope, 2 weeks, if that helps you at all. But effectively, we have taken some instructions on that issue, and that's essentially what we're being told.
Yes, I think we benefit from perhaps some additional of why you don't feel it's important, so I can consider Mr. Kelly's request in more detail. It might be something that we leave perhaps from the note of the meeting. So if you were able to give a summary of that position really as soon as possible after our agenda meeting closes, that it might be on board before we finalise the note of the meeting, and that would give you clarity on the scope of the ornithological additional submissions. Would that be possible?
Yeah, I'm happy to do that, ma'am, and I'm sure those instructing me have taken on board that you'd like it as soon as possible, ma'am.
Thank you very much. Mr. Finlay, I'm assuming you don't have anything to add on the ornithological matters, but please tell me if you do.
No, I don't. Thank you very much.
Thank you. This leads to another point where we're looking for additional clarification, and it's to do with peat. You'll see from the annex that I'm seeing peat as something that seems to straddle both the sort of hydrological and geological issues as well as ecological matters. And it seems to be the definition of deep peat and how it's being applied in various assessments and reports provided in the environmental information. So the purpose of the next item is really just to try and sort out what is deep peat in those contexts, and does deep peat change when it's being assessed in the context of geological or peat hazard matters as opposed to ecological matters. And I think that would be helpful in resolving not just a matter raised by the RSPB, but also one by the Scottish Wildlife Trust in an earlier objection from them. Do the parties have a view on additional information on that matter?
Well, ma'am, anything that can assist you on that, I'm sure we can provide. I'm picking up at the moment that really it's simply you want clarification as to when deep peat's being referred to, essentially, what measure is being used to define it as deep peat and whether it's being consistently applied throughout. I think I understand essentially that's what you're looking for.
I'm trying to find out why the various pressure groups and community bodies, why they are seeing a conflict in terms of the way deep peat has been assessed in the various documents. So just to clarify that, and if there is an error, is that we deal with that and find out what implications that has for any of the information that's been presented to us. Does anybody else have a view on the issue of updated peat information? Mr. Kelly or Mr. Finlay? And this leads us, because it is also connected, it leads us to just seek further clarification if necessary, or actually just to lead on from it anyway, the carbon calculations and the payback period. There is a question about the increase in the payback period to 4 years when it's associated with a reduction in the number of turbines. The information presented in the last round of environmental information seemed to be less than carbon calculator information presented in the earlier iteration of the environmental information. So I'll be looking for an update and perhaps additional clarification on how the payback period has increased to 4 years, just additional dialogue on that. Mr. Fraser?
Yes, again, ma'am, I'm sure there's no difficulty in providing that to you.
Now, there's an extra item I want. Apologies for it not being on the agenda, but it does stem from some of the RSPB documentation. I'd hoped to maybe have a word, find out more from them today, but it's not to be. The RSPB highlight that the full country is expected or hoped to become a World Heritage Site, and that it's currently on the tentative list. It seems to have a status in its own right. the applicant doesn't seem to have any knowledge of the World Heritage Site proposal, and therefore has not discussed that in the information that has been presented to us so far. So I would really like to also have an update from the applicant on the tentative nature of a World Heritage application, and also to find out if there's any mapping of the tentative site that might have some relevance in a consideration of this proposal. I'm not sure that the applicant has direct access to things like the mapping of the tentative site, so I'm also inviting the council, perhaps if they do have any additional knowledge, because perhaps they're a partner body in promoting this proposal, that perhaps they could provide any factual information that they may have regarding the current status of the World Heritage Site proposals. I'm sorry to pass this on to you at short notice, but I was just wondering if you have any, if that would be agreeable, if you'd be agreeable to that, please.
Well, ma'am, I'm sure we're happy again to help as much as we can. I don't know, I'm afraid, just what information we will have access to, but anything that we're able to provide you with that might assist, I'm sure we'll be happy to do so, ma'am.
Mr. Finlay, I'm sorry, I know this is catching you unaware, so you might not have been briefed on World Heritage Site issues. But I'm wondering if there is anybody from the council here who knows if they have any additional information.
Well, I'm instructed that it doesn't have any status as yet, but the proposed boundary is likely to be identified at some stage next year. And I understand we have suggested it for inclusion in the for MPF 4, and we are a partner body. And SNH may be the best person, I'm being told, to provide the most up-to-date information. That's the feedback I've had on our alternative communication from those that are listening into the call.
Yes, thank you. That's helpful. I know it's in a process rather than a fixed outcome at the moment, and really that's why I was looking for the most up-to-date position. I think it might be useful that I consider this in a wee bit more detail and provide a bit more clarity in the note of the meeting as to how we might approach that. Perhaps we would ask the council to provide, or Nature Scotland to provide, whatever information they have on status, and then allow the applicant an opportunity to assess the implications that it might have, the evidence they've presented on ecological matters and other impacts. So I think I might leave that for note of the meeting, but it's noted that the council probably has the factual information, but the applicant needs to perhaps consider that in their evidence. Okay. And that brings me round to policy matters again. Obviously, I've already indicated that we'll definitely need an updated position, but we consider that actually assessing the compliance with policy might be a matter that would work as a proper and full written submission by all parties that have an interest in that matter, as part of and as in the run-up to any inquiry or hearing event. So that it's done at the most appropriate stage in the proceedings. So really just to look for views from all parties on whether they would wish to present policy assessment information as on the basis of written submissions. Mr. Fraser.
No, ma'am, I'm afraid we would ask if we could have this as a hearing. It's been our experience, I think, various members of the team, that it has generally been dealt with as a hearing in the more recent inquiries. And we do think it's important, given that a lot of policy has been changing fairly recently, and in some cases assuming greater importance, that it is something that really needs to be explored properly at a hearing, rather than simply being left to written representations. I can go into that in a little bit more detail if you want me to, ma'am, but that essentially is our position.
Mr. Finlay, do you have a view on that?
Yes, ma'am. I'm afraid I disagree with my own friend. It does depend upon what is going to be taken into account. The two likely witnesses in this case, Mr. Bell and Mr. Heinsohn, have just, if you like, crossed swords on general policy matters at the Glen Sherry inquiry, which did involve significant additional issues of wildland policy, which I don't think is an issue with, certainly with Highland Council here, Cairngorms National Park policy, and claimed benefits of national importance, which aren't suggested here. So there were significant further issues there, but the basic policy position is frankly well trodden territory between applicants and Highland Council, with little that's in dispute. The one area that tends to be disputed is the extent to which there is perhaps a change in the decision-making process, whether the balance, for want of a better expression, is tilted towards the applicants or not, as the case may be. But in our submission, that is quite capable of being expressed. And Mr. Bell usually expresses it extremely well in his evidence. And we wonder what particular benefit there would be to you of having an oral hearing session. If there are issues that are raised in the submission you do think would benefit from an oral hearing session, no doubt you could ask them. But that's our position.
And Mr. Kelly, would you have a view on the policy position?
Yes, ma'am. Thank you. In this occasion, I would agree with the applicants. Our view is that whilst there are a considerable number of policy matters that can be set out fully in hearing statements in advance of oral process, the final conclusions on policy depend on the evidence which you will hear at the other hearings or inquiry sessions. So my preference is for there to be a hearing session on policy held last. The experience to date is that it's normally possible to narrow down the areas of disagreement in advance, or anticipate the areas of disagreement in advance, and end up with a relatively short policy hearing session. Sometimes only half a day, sometimes slightly longer than half a day, but we think it's important to have that opportunity to speak to some of the key issues. So yes, no difficulty with a detailed hearing statement in advance, but we would look for a short policy hearing session to be held last. Thank you, Ma'am.
I can see there being benefits in looking at the policy evidence being quite focused on the inquiry, the LVRA matters, but we're always going to come and discuss the inquiry or other procedures necessary to consider LVRA matters. I'm wondering if I might return to this particular issue of policy as to whether or not Mr. Kelly's suggestion that the policy discussion relates to the areas that are in dispute, such as the landscape visual impact position, and not a full rehearsal of all policy matters. Perhaps we might return to this at the end of our discussions once we've looked at the procedures for landscape and visual impact assessment under inquiry or hearing process. We're going to come to that fairly shortly, so I think I might leave that there, but I take on board your points, unless Mr. Fraser, you want to come back on anything there.
I'm happy to leave it. I think we would actually be asking for a wider policy hearing than Mr. Kelly is envisaged, and perhaps you're envisaging listening to Mr. Kelly, but I'm happy to come back to it later if that's the right time to deal with it.
Right, that takes us to the other bit of written submissions, and it's the set of conditions We've previously written to the council and the applicant to see if they can start work on a set of draft conditions. I don't know if any progress has been made on that so far, but I note from the report of handling that the council produced that they also have aspirations for legal agreements or something similar to deal with financial bonds for road wear and tear and site restoration, possibly the appointment of a planning monitoring officer, and also dealing with off-site compensatory tree planting. So really just looking to see, has there been any progress with the draft conditions and discussions on how these potential legal agreement matters could be addressed, bearing in mind, as the parties probably are aware of, the energy consents units generally will not enter into legal agreements and don't defer issuing any approval should that be the outcome, subject to a legal agreement, as might be the case with a planning application. So really just looking for some update or progress on the draft conditions at this stage, and then I've got another question after that. And Mr. Fraser, do you know any progress?
Well, my instructions are, ma'am, that the council requested that they prepare the first draft of the conditions, and we're still waiting to see them. I hope my instructions are right on that, but that's what I've been told anyway. So in short, I can't report any progress at the moment.
Mr. Finlay?
Yes, I assume that's correct. I know that we started work on the conditions. I've been informed that, and I'm also told that it's unlikely that we'll be seeking any legal agreements. Certainly, my experience with Highland Council is that for the type of matters that you've referred to, they're quite content for them, at least at first stage, to be covered by condition. That condition may then, in due course, give rise to a legal agreement, but at this stage, dealt with by condition. So we will, assuming it is the onus does lie on us, we will make sure those matters are progressed, and hopefully there won't be any significant or minor differences between the parties in terms of numbers of issues in dispute.
Mr. Kelly, do you have any view on that at all to add?
Yes, ma'am. If there were any oral evidence procedures on conditions and agreements, we would not be looking to take part. Our simple request in this matter is to have the opportunity to comment on drafts, and that's all we would seek, to comment in writing on drafts.
Okay, so that takes me to my second point, really, and it's about at what point in the process can we expect to see the draft conditions. In my preferred approach here is that we get the conditions as early as possible. That allows us to do two things. One is potentially consult with interested parties, perhaps share them obviously with Mr. Kelly, but importantly perhaps let Nature Scott see the conditions and make sure that they are going to address the matters that allowed them to withdraw their objection. You'll see that I've kind of set then the preliminary timescale down as the conditions becoming available in the early part of January. But also the second reason for looking for them as early as possible is to establish if we do need a hearing to discuss any areas of dispute or concern in the terms of those conditions. So the earlier into January we can get the draft list and confirmation from the parties that everyone's happy or not, then it will allow us to make the final arrangements for any hearing that might be necessary, which we think would be the third way of discussing any dispute in conditions, would allow us to do that. So my question really is, do the parties think they can meet that provisional date of 11th January as a deadline for the draft conditions, or is that likely to be pushed back to February along with the landscape and visual information? Mr. Fraser, have you got any information on that?
Well, if my instructions are correct and we're waiting for the council to produce the draft, we can't really answer that question in one sense because we don't know when we'll get it. I wonder, ma'am, if a sort of compromise might be that we work to try to have them by the 11th of January, but bearing in mind, I think that I was being listened to sympathetically about asking for the 1st of February for the other matters, that perhaps that's given as an end date, so to speak. So we work for the 11th of January, but we've got, if necessary, up until the 1st of February.
It may be, if I can assist, I'm told that we would hope to have a draft set of conditions out by the end of this week. That may slip into next week, but that should then give learned friends some indication of how long it would take to respond. But one matter, I don't think there'll be a final set, because one matter that may need to be dealt with is aviation lighting. Whether it's the 11th of January or the February date, I'm agnostic. But no doubt, once the draft is out and the ball is running, hopefully matters can move forward reasonably.
Well, that's positive. If we know that the conditions are progressing during December and they're not being held back necessarily before the end of the year, then there's a good chance that there'll be a working set that we can start to identify any areas of concern into January and before the start of February, if possible. We'll come back to the possibility of a hearing, or maybe I'm just looking at the time, because that's us now. We've been here for an hour. How do the parties feel? Do you want to take a break, turn your video off and get a breath of fresh air, or you want to crack on and we'll just get this finished today? Does anybody have a view?
Ma'am, can we have a 10-minute break, please?
Okay. Mr. Fraser, is that all right with you?
I don't. I was going to say I'm fine cracking on, but I'm not objecting to 10 minutes now.
Okay, Mr. Finlay, is that all right with you? Yeah. So 10-minute break. What we'll do, you just switch your video and your audio off, and we'll press the button again at 3:10 and restart as we move into looking at inquiry and hearing procedures. Thank you. Okay, that seems to be everybody back who was visible before, so that's fine. That takes us on to the draft inquiry procedure. I don't really have any notes to add to that. I think our preferred approach is to look at landscape and visual impact information and also wildland matters as an inquiry topic, or two separate inquiry topics. So I'm looking for parties' views on that as an initial question, and whether or not it should be one or sessions on these matters. Mr. Fraser.
Well, excuse me, I'm sorry. We certainly wanted as an inquiry topic. We're in entire agreement with you on that, ma'am, and we were happy with the way that you had laid it out in your annex.
Mr. Finlay?
Well, Highland Council's preference would be a hearing session, but I understand what Mr. Fraser said, and I've seen your note, so I won't take time seeking to convince you of a hearing session, merely to mention that at our recent pump storage inquiry, there was a very good hearing session dealing with landscape and visual. As to the splitting it into two topics, that makes sense because Highland Council aren't going to, I imagine, be attending, say, perhaps by way of a watching brief, the wildland session.
Thank you. Mr. Kelly, do you have anything to add?
We would have been content with a hearing session, but we would not resist if you wish to have the two inquiry sessions as per your note. Our concern is simply going to be how best to present the wildland evidence, drawing on the recent experience of Glen Sherrill, but that's something we will address in the coming weeks and keep parties informed. But happy to rest with what you want, ma'am, and certainly support two separate sessions. One to deal with wildland and one to deal with landscape and visual.
Thank you. That's really helpful. So the next question then is really how long would these inquiry sessions take in terms of days or hours, and how best should we consider timetabling that? Mr. Fraser?
Well, ma'am, I think we probably would suggest allowing a little longer than perhaps would be normal anyway, simply because, assuming it's going to be a virtual inquiry, because I think our experience is that, if anything, tends to take slightly longer. And we thought to cover the whole of the inquiry session for landscape, so that's topics 1 and 2 together, so to speak, perhaps of the order of 3 to 3.5 days.
Mr. Finlay, I saw the council's note that they were looking at 3 days just for landscape and visual. Do you have anything to add?
No, 3 days might be lengthier. Purely for landscape and visual, it may be possible to deal with that in 2. But I wouldn't disagree with my friend's overall estimate. I would suggest that's a sensible time estimate for both sessions.
Right, that leads us on to a little bit of discussion about how we might time the submission of statements of case and core document lists and the actual documents themselves. You'll see in the preliminary timescale under Annex E, we were assuming in that timescale that we had the updated landscape and visual information, which is obviously going to be quite important in this case, that we would have that at the beginning of January. But if that's at the beginning of February, I took the 10-minute break we had, and you may have done as well, just to have a look at what that might do to the timetable. I was imagining that if the landscape and visual information is available on the 1st of February, that we allow 2 weeks to share that information with Nature Scott and with Mr. Kelly and any other interested parties. And that assuming we can get 2 weeks is sufficient for Nature Scott to come back with revised comments, that we allow it then another further week for any statement of case to be finalised for the inquiry. That would push back the submission of inquiry statements to the 22nd of February, allowing 3 weeks for some kind of exchange and consideration of the additional landscape and visual information. I'm wondering, is that 3 week period sufficient, bearing in mind sort of 2 weeks to let Nature Scott give us some views, and then a week for you to add those into your submission? Mr. Fraser, any thoughts?
I think that's broadly what we tentatively envisaged if you agreed to the LVI going back 3 weeks. Basically, it would effectively be pushing the rest of the programme back 3 weeks, ma'am.
Mr. Finlay, do you have a view on that?
My concern is that just a feeling that may be slightly tight if there's got to be some interaction with Nature Scott. I was wondering whether that would be better 4 weeks in total, just to give a little bit of leeway, so that the parties hearing inquiry statements can be, statements of case can be as full as possible.
Mr. Kelly, do you have a view on that?
Thank you, ma'am. The Aracleoc extension section 36 inquiry will be running in the first couple of weeks in February. So I have to bear that in mind. I'm involved in that. I think Mr. Finlay's suggestion of a 4 week period would be fine, providing what you're looking for is in effect a statement of case. You're not looking for inquiry reports at this stage. It would simply be a statement of case as we normally have them. Then if that is so, I think notwithstanding Aracleoc extension, a 4 week period in February would be fine.
I think you've muted yourself, ma'am.
Sorry. Whether you call them inquiry statements or reports, I'm really looking for the key position of the parties to be set around 8 weeks before the inquiry. For 2 reasons. You'll see somewhere else in the paperwork we've provided that because our administrative staff are all working from home, we need the extra time to manage the digital documents and various things. So we're looking at getting in statements and documents and the list of documents all grouped together at the 22nd of February. And that gives us the best chance of making sure everything is entered onto our system appropriately, with plenty of time for people to see these documents. So I don't see a great problem in adding a 4th week in that period, but I would still like to see all the submissions that come from that being concluded as early as possible, obviously with the exceptions of the recognitions themselves, which I would accept would be much closer to the date of the inquiry. But it really is to try and get as early as possible all the documents, the list of documents and the named statements case ready. So if I allowed that extra 4 weeks to act on the landscape and visual information, I really would be hoping to secure everything else as soon as possible together. But I'll obviously take advice on whether or not there are logistical issues in providing these things separate from one another chronologically. Mr. Fraser?
Ma'am, we have no difficulty with it being pushed back an extra week, so I think that would effectively make it the 1st of March. But I think we would reiterate the point you make about the importance then of having the documents, and not just, I think, what might be, Mr. Kelly was envisaging effectively simply a shortened précis of what he's going to say. I think if he's going to produce a full report, that's what we'd be hoping to see.
Mr. Finlay, obviously the 4 weeks would suit you. Are you happy with the other documents all coming quickly on the back of that?
Yes, I think Highland Council would be happy for our, as I understand it, would be the everything but the recognitions would be due effectively by the 1st of March.
Mr. Kelly, is that going to work for you?
Obviously we will fit in with what's agreed, but I'll need to consult with the team because I had assumed that we were looking through the normal process of a statement of case followed by submission of the detailed evidence, the inquiry statement, something like 2 weeks before preconditions are due. We had not assumed jumping straight from the updated information to full inquiry reports, but we'll just have to fit in with what's agreed. But it's not what I had anticipated. It's not the normal procedure. Normally, we'd be looking for a statement of case as an intervening document based on the updated information. But as I say, we're only a third party. We'll fit in with what's agreed.
Well, I'll take it on board, and if there is, when we re-examine the timetable, if there's a way of giving a little bit of space between some of these items, then we'll do the best we can to accommodate it. I'm just conscious, obviously, that the time periods are slipping and moving outwards into 2021 as we speak, almost. So I'm just conscious to try and keep it on as tight a rein as possible, so that we can keep on top of it and properly apportion time and effort at the right time in the new year. But I'm really, obviously, it would appear that we are progressing on the basis of an inquiry for landscape and visual information with wildland as a separate topic, and that's very helpful. And it might be useful just to look at the potential inquiry dates that would come from that. So allowing a 4th week into that equation, we're still looking at, sorry, I'll just get a proper diary. We're looking at somewhere either the week beginning the 19th of April or the week beginning the 26th of April as a possible week to hold as much as possible of any inquiry or hearing process. It would be ideal, obviously, if we can focus it into 1 week, but we'll need to see what the timings are. We circulated an email before the inquiry just to say it would look like we were going well into April and possibly May for availability. So it might be prudent now to look at availability across the teams for those 2 weeks, the 19th and the 26th, and we'll look at what's available for all parties, and maybe starting with Mr. Fraser again. We seem to have lost Mr. Fraser.
I'm sorry, ma'am. I was trying to juggle 2 screens and it wasn't quite working for me. I do apologise, ma'am. My understanding is that there's no issue at all with respect to us for either of those weeks, i.e. that's the week beginning the 19th of April or the week beginning the 26th. But I do understand that there may be a difficulty to the council that the first week was the latest information we've received.
Yes, we have a difficulty with the first week. We're all available for the second week. We've got competing commitments in the first week. We did let Mr. Bell know that this morning, but it may not have filtered through yet. But I'm glad Mr. Fraser got the message. But we're the second of those 2 weeks. All our team are available.
Mr. Kelly, what's your availability?
No issues with availability. If parties are like on that week of the beginning Monday, the 26th of April, that's fine.
Right, thank you. That's really helpful. That allows us to go into the next discussion with a bit more certainty. So the next item that I have, I would normally look at trying to start an inquiry perhaps on a Tuesday morning, but that tends to be when we're in a village hall in the middle of nowhere, where starting on Tuesday often is a bit easier for travel arrangements. But I can't see any reason why we wouldn't be able to start on a Monday and have all 5 days available to us to fit in the inquiry and any necessary hearing sessions that come from that. So that would be my preferred option, is to set aside a full week and see if we can timetable all the necessary stages of that into the one week. So it takes me to the last item, perhaps on the last formal part of the agenda, is to do with the draft hearing procedure for conditions. And obviously that then leads us to this hearing procedure we might now have for policy matters. We don't know if there's a serious dispute at all in the terms of the conditions, but it would be prudent just now to set aside time in the inquiry programme for a hearing to take place on that. Are you happy that we proceed on the basis that we need a day or half a day? What would be your best estimate as to how we should timetable for the discussion on conditions, Mr. Fraser?
Ma'am, we're happy with a hearing session being timetabled in for conditions. It's my experience, I have to say, ma'am, that normally reporters have the best idea how long it might take, because to a degree they control it on just how detailed an assessment they want. I would have hoped half a day would be sufficient, but it would obviously A, be in your hands, ma'am, and B, just depend on how much, if any, disagreement there is.
Mr. Finlay?
I would suggest half a day should be sufficient too. If it may well be less than
that. Mr. Kelly, you'd said you had no particular interest in it. That's fine. I would agree with you that it is normally within our purview to decide the scope of the hearing, but in the absence of seeing the conditions, we are a little bit in the dark at the moment. So I'm really just looking at a best estimate as to how we make sure that we don't miss out on timetable in sufficient time. We obviously can expand it or continue in January when we know what the level of problem there might be in the terms of the draft condition. So if we've got, and I think that
Ma'am, can I just raise a point before you move on? It's just this, that I'm going to be in Stornoway the week before, and if I know that the inquiry sessions at the moment, wild landscape and visual first and wildland second, it might assist me if you took them in the reverse order, given that I will be travelling back from Stornoway, potentially even on the Saturday. And that would enable us to hopefully deal with everything in that week. But that would certainly just provide a little bit more flexibility for Highland Council, if that is the case.
Mr. Fraser, how would you feel if the wildland matters was discussed in inquiry before the wider landscape and visual?
Well, I don't want to be difficult for Mr. Finlay, but I must confess I would have thought the logical order to deal with them was the order that you had, ma'am, and I would fear that we may end up taking longer dealing with the wildland issues if we haven't dealt with the landscape and visual ones first, if I might put it that way, ma'am. That would be my concern. But I obviously don't want to be difficult for Mr. Finlay, but it does seem to me that the better order is that you set out yourself.
Mr. Kelly, do you have a view on the order of wildland and landscape matters or visual matters?
No, ma'am, no view on that. Again, we fit in with what's agreed. It makes no practical difference to our evidence in the order which it's heard.
Well, I have a certain sympathy with Mr. Fraser there in terms of the order, only in that I expect there to be a discussion on visual and potentially landscape impacts arising from aviation lighting that perhaps then would be repeated in some form or other in a discussion on any aviation lighting effects on wildland. So I can see there being a crossover between the two sets of evidence in some way, that there is going to be a sharing of information in terms of the two issues. I think I might have to think about how best, whether or not there's anything to be gained by the order.
Sorry.
Sorry.
Can I just suggest that we start on Tuesday then instead of the Monday?
I'm grateful to Ms. Hayward for that suggestion. I just think that, as I understand it, we may be tight to finish everything within 4 days. If it's 3.5 days for both inquiry sessions and half a day for potentially conditions and policy, we would squeeze it within 4. It was just a suggestion. My view, there may well be a crossover, and certainly there was at Glen Sherrow, but there's a crossover with whichever you start first. For instance, if there's aviation lighting issues, they're going to have to be discussed to a certain extent at both sessions, I imagine. I'm very happy to leave it in your hands as to the reality of whether there is a crossover. I can certainly be in attendance virtually on the Monday. That's not an issue, but it would assist me in preparation if I wasn't didn't have to cross-examine until the Tuesday. But if needs be, I can cross-examine on the Monday. But I'm happy to leave it for you and Ms. Hayward to consider.
Well, it might be helpful now to look at the length of time. We obviously put to the side briefly earlier on the time that might be taken to discuss a hearing on policy matters and whether or not that hearing would be the full range of policies relevant to the proposal or those focused on landscape, visual and wildland matters. Mr. Fraser's preference was to look at the full relevant policy compliance assessment and to have that as a hearing. If that was the case and we were looking at all policy matters at a hearing, what kind of timescale are we looking at to consider that? I know, again, hearings are dictated by reporters, but we're uncertain yet as to the extent of the evidence that's going to come forward in advance of the hearing. So just have a best estimate just now.
Well, ma'am, I have discussed this with Mr. Bell, who would be giving the evidence effectively at the hearing, and our best estimate at the moment, I think, would be half a day.
Mr. Finlay, do you have a view on that estimate?
Half a day is a sensible estimate in the circumstances. That it may well be shorter, but probably best to err on the side of caution.
Well, in looking at all of those together, and if we are able to approach the inquiry part of the process as a 3-day event and timetable 1 day for a hearing into policy and conditions, then it would be feasible to start on the Tuesday and to finish on the Friday and put the policy and the conditions into a single hearing event on the last day and have the inquiry evidence on the Tuesday, Wednesday, Thursday. That looks feasible. I'm not setting that in stone just at the moment, but that looks like a viable solution based on the best estimates you've been able to give at the moment. Would everybody be reasonably comfortable with us progressing at least as our starting point from today's meeting?
Well, sorry, ma'am. I did say 3 to 3.5 days for the inquiry, and I must confess, in the hopes that you agreed with us on the hearings for the other two matters, the conditions and the policy. I'd envisaged that would effectively be the Monday to the Thursday on the landscape and visual, and we'd have the Friday for the other two matters. And I thought we'd be fine with that. I must confess, if it's three days for the landscape and visual and the wildlife, the wildland, I should say, it might be tight. Is my only concern.
I'm wondering what would be, I'm trying to avoid going into the next week, but if we were to push conditions into this next week as a separate day, is there timetabling issues for the week after? That would be.
If it's a condition of going into the next week, then subject to you considering which inquiry session you have first, I will ensure I'm in a position to start on the Monday if necessary. I think getting into 2 weeks is administratively inconvenient for everyone. But if you could still give some consideration to potentially having wildland first and landscape and visual second, I would say that I think there is a good chance of finishing landscape and visual and wildland within 3 days. Our objection is a visual impact objection, which will cut down the extent of time that you have to cross-examine, because much of that will depend on your views from your site visit and any further site visits you take, having heard the evidence. Yes, I'm very happy to leave it in your hands, but I think probably all parties prefer not to go into a second week unless absolutely necessary.
Would you agree with that, Mr. Fraser? We keep focusing on a 5-day timetable.
Yeah, I would. I think 5 days is what we need, ma'am, and I obviously would much rather deal with it in the 1 week. Can I just flag up a warning to the Monday of the following week? I think it's a public holiday actually, so you definitely having to go to Tuesday, I think, if you went into the next week. But I just remind you of that. But our preference, I think, definitely would be to deal with it in the 1 week.
Well, I think that it's a really good starting point for our timetable. I'm quite happy. I think we'll be able to work something out from that. I'm going to obviously take some time to look at the wildland and the LVIA information as to whether or not it could be approached in a different order to assist Mr. Finley's arrangements. And we might just confirm that in the note of the meeting. But it does lead us quite neatly into the second last item, which is about whether there's any scope for agreed matters. Now, the timetable, if there was, the timetable for that is obviously to get that settled by the 1st of February or the 1st of March, either to get that settled with the landscape and visual information or with the statement of case and the core documents submission on the 1st of March. Ideally, I can see some potential for the parties to resolve some of the policy discussion. Certainly the relevance of policy could be settled, I would hope, in agreed matters. But there may be other areas where there can be some agreement within the landscape and visual impact work as well, bearing in mind, as Mr. Finlay just pointed out, that their objection is emphasises more visual concerns rather than landscape concerns. So I really would hope that you would look at that. I don't know if you have a view on whether or not there's scope for agreed matters at this time, but obviously I've identified where there might be, but I'd appreciate to see whether you've identified any other areas. Mr. Fraser?
Yes, ma'am. I mean, we would hope that certainly on some of the policy matters, we will be able to come to some form of agreement. Certainly as to relevance, one would hope one could come to agreement. There may still be issues, however, with relation to that. And likewise, as much as possible around landscape and visual matters as we can agree, we're happy to come to some form of agreement on. The other issue we were hoping to be able to come to agreement on would be the nature of the aviation lighting and the extent of its visibility. I suspect it will be more the significance of its effects that's left to discussion, if I might put it that way. But we would hope to try to reach as much agreement as we can on those matters.
Mr. Finlay, do you see any other scope for agreed matters from your side?
No, I think you've covered the areas, and I'm sure that there will be scope. And I was particularly going to volunteer Mr. Fraser's class to put forward a draft, which is usually what they want to do in any event, and we can comment. But I know that, for instance, in policy terms, we got Mr. Bell and Mr. Heinsohn, as I've already indicated, have got experience of coming to agreement on a number of matters, and we can usually deal with a number of matters on landscape and visuals, so that the issues and disputes are highlighted.
That's positive. Mr. Kelly, do you have anything to add to agreed matters?
We will look at the draft, ma'am, and comment. In general, I'm nervous about statements of agreed matters going beyond simple statements of fact and starting to go into areas of evidence that may or may not be in dispute. But if there's an agreed statement which sticks to the facts, then we would hope to be able to contribute to it, but we may not. We just have to see the draft.
That's good. Obviously, I would leave that to the parties to see how much they can progress in the coming weeks. It leads me now, I think, to I've put areas of other business, items of other business at the end. There is one question I have. It doesn't quite fall into written submissions or update, but from our site visit to the houses on the road down to the site from Strathy, there were 3 habitable properties at both sides, which appeared to be a lodge, a bothy and a cottage. They may or not have that postal address. And they seem to all be habitable, and they may be holiday homes, they may be permanently occupied. And I thought it would be useful if the applicant could confirm exactly what was there and whether or not they are all holiday homes or permanent residences. And similarly, we visited Darling Well, which is within, I think, the area controlled by Strathy North, the separate wind farm there. Again, the original house is empty, but there are 2 other habitable buildings. One appears to be a bothy for workers or something like that, and the other seems to be a habitable cottage. So I thought it would be useful if the applicant could just confirm to us the nature of the houses that are closest to the site, and how these, whether they are all holiday homes or officially unoccupied because of some other agreement with the other wind farms. There also is the lodge in the applicant site itself. I don't know if I pronounce it properly, Breathy Lodge, which is actually within the site, and it's expected that would become the hub for the substation or other support facilities. It appears to be unoccupied, but it may have been a house in the past. It's difficult to tell. It could have been residential, but it's difficult to tell from what's left at the moment. It seems to be one single building. So really just to ask that we could get some confirmation separately. It's not really written submissions, just confirmation as to the nature of the houses in the Strathy area between the site and the village of Strathy, and how they are occupied, and if they are controlled, or the applicant has any ability to control those properties. Mr. Fraser?
Yes, are you expecting that in a note coming to you fairly shortly, ma'am? Because I can't answer that question for you immediately, but I'm sure we can send a note this week, hopefully, to you to let you know. The only question I'd ask, whilst everybody can hear me, so to speak, is I'm assuming that those who instruct me know the properties that you've referred to, so that they can, if there's any doubt about which ones you're referring to, I suggest they better just ask now, so that we do know that we answer the right ones now.
Well, it's not too great a problem. I think I can put it in the notice meeting as a sort of a secondary item, just, and I can define the addresses more accurately, and then just ask for clarity on the occupation use of the properties.
That would be very helpful. Thank you, ma'am.
And the other item I had as an area of other business was really the form of the additional documents to come. We see from another inquiry and hearing process the use of a shared resource in terms of the core documents, putting them all onto one memory stick that's managed by one of the participants in the inquiry. There seems to be benefits arising from that in terms of the electronic page numbering, and in our virtual world that we'll be inhabiting at our inquiry, it's easier perhaps to manage the documents if we're looking at the same list and the same page numbering. Would parties intend to enter into that type of approach where there's a common memory stick or something like that that holds the document list? Mr. Fraser?
I have to say, from the point of view of somebody who won't be responsible for doing it, ma'am, it seems a very good idea. I think that's a matter my solicitors will have taken on board, and if it can be done, I'm sure it will be done.
Mr. Do you have a view on that?
It was certainly very useful at the Glenshire inquiry, because it just, when you're doing matters virtually, it makes it absolutely certain that everyone has the same documents in the same format on the same electronic page. So it is very useful, and I don't anticipate it's too onerous in the sense of having to produce it electronically and then producing copies of it, provided they're sent out sufficiently in advance. Is much easier than chopping down lots of trees and producing lots of paper copies.
Yeah, that's fine. Mr. Kelly, presumably you're okay with that as well. I think you're involved in the same inquiry.
Yes, ma'am, I've been involved now in 2 inquiries using that process. The only thing to bear in mind, again from Glenshire, is that it can be useful to get the USB sticks updated, and then updated sticks sent out, say 2 or 3 weeks before the start of oral evidence proceedings, depending on your precise timetable. But certainly that was very helpful at Glenshire, and as Mr. Finlay said, it meant that everyone was referring to the correct document number and the correct electronic page number. It helped a lot.
That's good. Perhaps we can, obviously we don't need to agree anything as detailed as that today. It was really just to put those ideas to the parties, and that the note of meeting will ask for ideas as to how best we can manage the core document lists at the time, taking on board Mr. Kelly's suggestion that if there are updates, we need to find a way of managing that as well. I don't have any.
Sorry, ma'am. I have had a message actually from Mr. McGovern who tells me that Pinson's is certainly happy to host a shared platform, and I suspect it's then I'm not a technical chap at all, but I suspect it's then a question of simply producing the memory stick from the shared platform. I suspect, but I'm sure outside of this meeting there can be a discussion between the parties and be sorted.
Really, that was my intention, is just to flag it up as something that we do need to work on to try and make the virtual event as efficient as possible. I don't have any other items of other business, but I'll obviously open that out to the parties in case they see anything I've overlooked. Mr. Fraser?
Yes, ma'am. I think you left it for me to come back on the LVIA and how it was going to be produced. I think it's our intention, subject obviously to there being no glitches with the printing, to try to produce a hard copy for the 1st of February, as well, obviously, as an electronic of the visualizations. I think everything else would be going electronically, but I think I can understand why Mr. Kelly asks for the hard copy of the visualizations. And subject, as I say, to there being no problem at the sort of printer's end, that would be our intention.
Thank you, that's helpful. Mr. Finlay, any other areas of business you want to raise?
No, nothing from me. Thank you very much, ma'am.
Mr. Kelly?
Yes, ma'am. Just 2 points. One, in relation to the visualizations, if the applicants intend to still rely on the 2019 visualizations, then I would like to see them in hard copy as well, please. Anything before that, I will look at electronically. And the final point, ma'am, is now you've fixed a start date for the oral evidence in sessions, which is almost a month later than your initial draft timetable. When you do the minute of the meeting, could you perhaps just look over the earlier deadlines to see if there's any leeway in them to give us some more time, given that there's a later start? I make the plea from my own part in that, as I said earlier, I do have our clear extension section 36 inquiry running in February. Is that one of the first couple of weeks of February? Thank you, ma'am.
Yeah, thank you. It was my intention to try and look at that timetable and refine it to take into account everything we've learned today about various commitments and the nature of the evidence that will be coming forward. So I'm happy to do that and see if there's any other benefits we can give the parties in terms of extra weeks here and there to assist. We've already accounted as best we can for the Christmas break, and we'll work from that forward. Ms. Haywood, is there anything you want to raise? I know you've obviously let me just carry on my own today, but is there anything else that you want to raise with the parties?
Mr. Kelly asked there about the hard copy of the Mr. Fraser, you're happy to provide that to Mr. Kelly?
I don't know the practicalities of doing that. I'm sure if it can be done, it will be done, ma'am. But given I don't have anybody over my shoulder, so to speak, at the moment to answer my question, I can't guarantee it simply because I don't know what the practicalities are. But I'm sure steps will be taken to try to do it as best we can. Can I, whilst I've got the microphone again, just check one thing? Am I to take it effective? I know, ma'am, your notes will be coming out fairly soon anyway, but am I to take it effectively that we should be booking out that week? I think it's starting the 26th of April in our diaries now, so that we know that that's reserved effectively for it.
Yeah, I think we've got to the point that seems to be the earliest we can achieve this and still ensure that the various parties are not overly conflicted with other commitments. I don't see any point in opening up the discussion of dates. And if we can try our best to find a timetable that fits all into 5 days, that's the intention. And I'm hoping the note of meeting will confirm that and put all those dates in place. But yes, I think 26th of April is our preferred week, and that's what will be in the note of the meeting. Anything else? Everybody happy? Well, that's really useful. We've managed to finish even with a 10-minute break. We've got through that in just under 2 hours, so that's quite successful. Thank you very much for your patience while we all learned how to use the mute button properly. Always a challenge when you get started on these meetings. So thank you very much for your time and your patience today, and it's my intention to have the meeting out within the week, and we'll start all our official processing dates really from that point onwards. And we'll see you in April, if not before. Okay. Thank you very much. I'm just going to end the meeting.